My name's Michele Hanisee, and I'm the president of the Association of Deputy District Attorneys for Los Angeles County. I'm not a politician and I'm not a sociologist. I'm a career prosecutor whose views have been shaped by meeting victims of crime and seeing for myself the harm that has been done to them. I'm here to talk to you today about three laws that came out of Assembly Bill 109, Proposition 47, and Proposition 57. We hear about all these bills and initiatives in the media, but it's hard to know what they're really about. They're just a bunch of numbers. So today I want to look at what each of them was intended to do and also what they actually did, including some consequences that were not represented as being the goal of these laws. The Cliff Notes version is that AB 109 transferred responsibility for housing and supervision of some sentenced felons to the counties. Proposition 47 reduced sentences for drug possession and thefts under $950, and Proposition 57 allows early release of state prison inmates and tougher rules to get juveniles charged as adults. AB 109 was called Public Safety Realignment. One thing all of these laws and initiatives have in common is that they use the word safe or safety in the title to make you, the voters, believe that they are about increasing public safety. Unfortunately, that's not always the actual result. AB 109 was passed by our legislators in 2011. It was intended to reduce prison overcrowding, so it created a system where nonviolent, non-serious, non-sexual felons, they're called non-non-nons, were housed in county jail instead of state prison. It also shifted supervision of those inmates from state parole to local probation departments. What were the impacts of those changes? A decrease in the prison population, which was intended, and an increase in the county jail population. But one of the unintended consequences was because the jails now had to house those convicted felons, the non-non-nons, they no longer had room to house the low-level offenders serving misdemeanor sentences, which is what the jails are supposed to be for. So the low-level offenders were getting released early to make room for the felons. And when the non-non-non felons were getting released, they were being supervised by local probation, which had no historical experience supervising these higher-risk individuals. According to the California Department of Justice's annual report on crime, after AB 109 was enacted in October of 2011, property crime rates did go down for 2 years. But remember, under AB 109, the convicted criminals were still being incarcerated. They were just being incarcerated in jail rather than in state prison. The big change is how they were supervised when they got out. Also, it didn't transfer existing prisoners. It only applied to new convictions. So the offenders subject to AB 109 would have to be arrested, prosecuted, convicted, serve their time, and then get released before you would start to see any effect. And 2 years later, that is when you start to see a rising property crime rate and also a rising violent crime rate. One of the important aspects to note about AB 109 is that these inmates are classified based only on their current offense. Some of them have really violent criminal histories, but if their current offense is nonviolent, they go to county jail as a non-non-non, and when they get out, instead of being supervised by parole, they're being supervised by probation under what is called post-release community supervision, and this is where we see the impact. Under the old system, if a parolee violated the terms of his or her release, they'd go back to prison for usually a year or at least 90 days. Under AB 109, all they get is 10 days in jail. It's called flash incarceration. The impact of the shift in supervision and penalties for violation are illustrated very well on the LA County Probation Department's most wanted list. On any one day, that list has 100 to 200 felons who were released to probation under AB 109 who have absconded from probation and disappeared into our communities. If you go click on any of the faces listed, it'll give you the details about that particular inmate. So let's look at who they're supervising. This is Jesse Henson. Jesse Henson is a documented gang member and has an extensive adult criminal history that began at the age of 18. His convictions include murder, robbery, theft, carrying a concealed dirk or dagger, and possession of controlled substances. He has served multiple state prison terms, the longest being a 14-year term for murder. But because his most recent offense was a non, he qualifies for post-release community supervision. He was released to probation in June of 2016, and he absconded in February of 2017. And his report in the LA County Most Wanted tells us he was released to probation under AB 109 based upon his current offense. It can't be good for public safety to have these felons walking away from probation and disappearing into our communities. A prime example of how the changes in supervision have affected public safety is the case of parolee Michael Mejia, who's charged with the murder of Whittier police officer Keith Boyer. Mejia had been released under AB 109 about a year before the shooting. During that year, he had been found in violation and given flash incarceration 5 times. If he had been found in violation under the old system, he likely would have been returned to state prison for a year, especially with repeated violations, in which case he would not have been in a position to shoot anyone. But under AB 109, he was repeatedly given flash incarceration. Now, I've seen a quote as saying that to say that AB 109 is the cause of any law enforcement officer's death is a political cheap shot. So rather than me speculating about what, if anything, AB 109 had to do with the death of Officer Boyer, I'm going to let you hear Mr. Mejia's own words and see the transcript of his interview that was played at his preliminary hearing in open court. More recently, Sacramento Sheriff Deputy Robert French was also killed by a felon who was on post-release community supervision under AB 109. The next big criminal justice measure was Proposition 47, the Safe Neighborhoods and Schools Act. Again, they used the word safe in the title, but was it? The key features of Prop 47 is that prior to 47, thefts under $400 were a misdemeanor and over $400 were a felony. Now, any theft under $950 is a misdemeanor. It also reduced straight drug possession to a misdemeanor. So what were the impacts? A decreased prison population. Again, one of the goals was to reduce the prison population, and an increase to county jail commitments for those new misdemeanors. But the county jail population was already at capacity from housing the non-nons under AB 109. So there was no space left to house people convicted of these new Prop 47 misdemeanors. So if they went to jail at all, they got released almost immediately. Following that, in 2016, there was a slight decrease in property crime rates statewide, but according to Los Angeles County Sheriff information, Los Angeles property crime rates went up significantly. Moreover, the violent crime rate continued to rise across the state. In December of 2016, the USA Today newspaper group did a really interesting multi-reporter, multi-newspaper, multi-story feature focusing on the different aspects of Proposition 47. Under Proposition 47, the money that was allegedly going to be saved in prison costs was supposed to go to the local governments for rehabilitation and treatment programs. But the state only saw about half of the savings they projected, and much of the money was diverted back to the state's general fund instead of going to the local communities. They also found that enrollment in drug treatment programs was at an all-time low, because without the threat of incarceration, no one would go. The defendants would rather get sentenced to county jail because they knew they'd get released within a few days. And they also found that the criminals were gaming the system, because they knew, as this man Daniel Harris said, that as long as they kept their thefts under $950, nothing would happen to them. And now we're faced with the most recent Public Safety Act passed by the voters last November, Proposition 57, the Public Safety and Rehabilitation Act. The key feature of Proposition 57, the voters were told, is it allows early release of nonviolent offenders from state prison. What the voters weren't told is that it also allows the Department of Corrections and Rehabilitation to award unlimited conduct credits, which allow any inmate, including violent offenders, to be released earlier. As for the nonviolent offenders in state prison, as you recall, AB 109 shifted housing of the non-non-nons to county jail, so there shouldn't be very many nonviolent offenders left in state prison. The biggest problem of Proposition 57 is that it did not define which felonies were nonviolent, which leaves the legal interpretation as any crime not on the violent felony list already. Here are some crimes which are not currently defined as violent felonies: human trafficking of a minor, hate crimes, assault with a deadly weapon on a peace officer, exploding a destructive device with the intent to cause injury, ADW with force likely to cause great bodily injury, domestic violence. The word violence is in the name of the crime, domestic violence, and it's not a violent crime. Solicitation to commit murder, not a violent crime. Also, Proposition 57, as it was written, allows enhancements for especially egregious conduct to be disregarded. It allows repeat offenders to be eligible for early release after serving the same amount of time as if it was a first offense. It allows a person convicted of multiple crimes against multiple victims to be released at the same time as someone who committed a single crime against a single victim. So a person who commits 20 burglaries of 20 homes is eligible for release at the same time as a person who commits one burglary of one home. And when people started pointing out that these type of offenders would be eligible for early release, we were told, don't worry, you can trust the parole board to only release non-violent offenders. But the California Parole Board has not exactly inspired confidence lately. Not only that, they operate completely outside of the public eye. Any citizen in the state can walk into any adult criminal court and they can watch a trial. They can watch a sentencing. But parole hearings are closed to the public. Attempts in Sacramento to reclassify some of these crimes as violent were defeated in committee. And now we know exactly who the Department of Corrections and Rehabilitation is planning to release as a nonviolent offender, because the regulations were approved in April of this year and went into effect June 1st. So let's look at who they say qualifies for early release as a nonviolent offender. I always like to show you the actual text of the regulations because I feel like no one could possibly believe me if I just told you what the regulations say. So here we have the definition of a nonviolent offender. It says a nonviolent offender includes the following: an inmate who has completed a determinate term of incarceration for a violent felony. That's right, you can see it right there. A nonviolent offender is someone serving a term for a violent felony. So it says an inmate who's completed a determinate term of incarceration for a violent felony and is currently serving a concurrent term for a nonviolent felon offense is a nonviolent offender. What does this mean? A concurrent term means the person was sentenced for committing more than one crime and the sentences overlap. So if you commit a violent crime and a nonviolent crime at the same time and the sentences overlap, you are a nonviolent offender according to the Department of Corrections and Rehabilitation. Here's an example of this at work. If a person was committing the crime of human trafficking of a 12-year-old child with the intent to commit a crime, which is a nonviolent felony with a sentencing range of 8, 14, or 20 years, and that person also molested that 12-year-old child, which is a violent crime with a sentencing range of 3, 6, or 8 years, and that person was sentenced to 14 years for the human trafficking and a concurrent or overlapping sentence of 2 years for the molestation, that felon would be eligible for early release as a nonviolent offender after serving only 2 years. And under the new conduct credit schedule, that person would for sure be released after serving less than 5 years of that 14-year sentence. But the Department of Corrections and Rehabilitation doesn't stop there. They also define as a nonviolent offender an inmate who has completed a determinate or indeterminate term of incarceration and is currently serving a determinate term for a nonviolent in-prison offense. So what does that mean? An indeterminate term is a life sentence. All life sentences are violent crimes. And you don't complete a life sentence until you either die or get released from prison. So as long as you're still serving your life sentence, even if you've met your minimum parole eligibility date under the life sentence, you haven't completed that sentence. So if you're serving a life sentence and you are currently serving a determinate term for a non-violent in-prison offense, which means you committed a new felony while you were in prison serving your life term, you are suddenly deemed a non-violent offender. This can even apply to murderers, and it basically incentivizes any prisoner serving a life term to commit a new non-violent offense while they're in prison. And finally, there are the sex offenders. The regulations excluded sex offenders from early release, but now they're suing because Proposition 57, as it was written, applies to all prisoners. It didn't preclude early release for sex offenders, so the regulations can't add something that wasn't already existing in the actual text of the law, and the sex offenders probably have a pretty good lawsuit. As a final collateral consequence, victims' rights are being reduced and eliminated. Under our state constitution, Marcy's Law, the Victims' Bill of Rights, victims are entitled to certain rights. That includes the right to be present at all parole or release proceedings and to be heard. Proposition 57 didn't get rid of those rights. It never mentioned any of those rights. So how did the Department of Corrections interpret the total absence of language about victims' rights in Proposition 57? They said victims may submit a written statement. Not appear in person, not be heard, just submit a written statement. Victims also have no right to appeal a decision of the parole board to grant someone early release. The inmates, however, may request review of the decision. The inmates have a right to appeal. As a result of Proposition 57, in July of this year, over 1,300 inmates across the state were recommended for early release by the Board of Parole Hearings. Over 800 of those were to Los Angeles County. Here is an example of one such letter obtained through a Public Records Act request. Note that it's entitled Nonviolent Decision Form and is dated August 15th of 2017. The inmate in question is Mr. Xavier Sarabia. Mr. Sarabia was convicted of attempt to steal a motor vehicle from another by brandishing a knife and demanding that the victim surrender his motor vehicle. That would be attempted carjacking. Carjacking is a violent crime. It was charged in his case as attempted robbery. Robbery is a violent crime. The letter notes the crime was violent. The letter goes on to describe that Mr. Sarabia, a repeat offender, had been out of prison for less than 2 years when he committed this crime. It also details his violations of rules while in prison, including possession of a cell phone while in prison. So what was the decision the parole board came to with respect to Mr. Sarabia? The Board of Parole Hearings approved Mr. Sarabia's early release as a nonviolent offender. Finally, it's not just the criminals in our own state we have to worry about. Criminals are coming to California from out of state because they're hearing about these laws. In May of 2017, Judy Turner was severely beaten by 2 men who broke into her home. Thankfully, a neighbor saw the men going in and called the police, and the 2 suspects were apprehended. The suspects were from Denver, Colorado, and one of them was wanted for a homicide. The neighbor, watching the arrest, asked one of the men why he was here. The man said, Prop 57. So I hope this has helped you understand why crime rates are going up in this state. Your local city and county governments are working very hard to develop strategies to ensure the safety of our communities. But they also need your help as citizens to reach out to your representatives in Sacramento and send the message that these laws are having adverse consequences for our communities. Go to www.legislature.ca.gov to find out who your senator and assemblyperson are, and write to them, email them, call them. We need to make it clear to the politicians in Sacramento that what we need is meaningful, adequately funded rehabilitation for those who can be rehabilitated, and meaningful punishment for violent and repeat criminals.